ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕುರಿತಾಗಿ ನಡೀತಾ ಇರುವ ವಾದ ಪ್ರತಿವಾದದಲ್ಲಿ ಸಿಎಂ ಸಿದ್ದರಾಮಯ್ಯ ಪರ ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ ವಾದ ಮಂಡನೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದರ ಲೈವ್ ಅನ್ನ ನೀವು ನೋಡಬಹುದಾಗಿದೆ.
While a microscopic examination or meticulous consideration may not be needed, cryptic orders would nevertheless fail to meet the requisite test. In this case, at para 51, the court concluded a clear opinion had been found by the investigating officer that he suspected the commission of an offence. Subsequently, on considering the material, the state government came to the same view. In the present case, certain important factors must be borne out. I am applying it here. There is no view at all found by the IO. Now, this is what I want. This is my problem. There should be, otherwise, the should be opening the floodgates. And my word friendly governor was not intended as a mark of insult. I am talking of a constitutional lacuna. If this 27.1 is accepted by your lordships against me, it's my submission, but if it is accepted against me, then your lordship is allowing this friendly governor or a opposite political color state government. And whereas all these concepts of governor above politics and neutrality is now gone. Let's not live in fictions. Whereas we have governors, we have got governors who are resigning from governorship and fighting elections.
No, now to seek.
There is no such thing.
Correct. No, now, if your submission is that the investigating officer only should seek sanction, approval from the hands of the competent authority, who is the investigating officer here to seek approval? There is no investigation now? Not yet commenced?
No, that he will
Not yet commenced?
That's a procedural matter. If somebody goes with a complaint,
that's what.
Appointed.
Somebody goes with the complaint. There is no investigating officer to form an opinion and seek approval. Who will seek approval?
Complaint. Now, let me answer, my lords. First of all, your lordship will decide it in a true case. Your lordship will not be asked, as they are doing, to decide a hypothetical.
No. I am only
on the inquiry. No, I am giving lordship answer. There's a very clear answer to your lordship. The dates in this case give the answer. This man files on 18th July, and the governor.
No, 18th July he registers a complaint.
Then 25th additional.
No, that is not taken note of, because I see the order. So for want of approval, he does not proceed further.
Then second is 25th of July, he files a further information to supplement the initial.
Yes.
Then 26th, he goes directly to governor in less than 6 days. Now, the query my lord is putting, in a case where there is no action, maybe a writ will lie to create an action. You can't say, I go today, give him 3 days and I go to the governor and bypass. 70 days can be bypassed because that's the way to do it. But therefore, the escape route to your lordship's very valid question would be that if I try to defy and don't ever give anything, I have no inquiry officer, I have no policeman, I have nobody appointed. Well, the lordship's writ court will settle it in 2 minutes. But whereas here, these dates are important because you are actually bypassing the system of 17A. 3 dates. 18th, he lodged a complaint with the Lokayukt police. 25th, he filed a supplementary information. 26th, he went to the governor. Where will the poor police officer will not function so fast, even if they have to function? Yes, if I am deliberately not functioning, if I am a police officer, if I am the state,
first 154(1) was 3 days before they going to the governor or registering the private complaint? No. When was the first complaint registered?
It is 18th.
18th June.
No, July.
18th July. First complaint.
Yes. 1 minute. 18th July is the first complaint by Mr. Abraham. Yes.
All right.
And he never approached the court saying that Mr. Policeman, you are sleeping. Mr. State Government, you are doing nothing. Please give a mandamus. If this is so, what prevents your lordship from having hundreds of people coming and saying, 70 days be damned, I am going straight to the governor? That's a point to be considered, Malas. Your lordship will.
And when did you go to the next higher authority? 12/8. 5/7, sir. 5/8. And before that, you had already sought.
He closed the doors. Actually, Malas, if your lordship investigates a very important question more, he then has power to go to the court. Not your lordship, writ court. He can go under 154(3) to the SP.
No, that's what I'm asking. 154(1) jurisdictional police, no action. 154(3) SP, no action, 200 magistrate.
No, I am going further. Writ court will give it for the asking.
And that also, a mandamus to register the complaint.
But you do nothing. You come on 18th, you go home on the 26th and say, look, I am bypassed. Thereafter, nobody is going to touch it. You gone to the highest officer in the state.
All right, yes.
So these harm. Now, just look at the reverse for a minute. Just look at the reverse. This is all right. You don't have an inquiry officer. You did this. Look at the reverse. Is your lordship not being asked to accept a gigantic principle subversive of the discipline of law that this 17A, what is left in it if everybody is going to the governor first? That's my reverse question.
Everybody, why will they go to the governor? Governor is the competent authority only to a few, not to everybody.
No, for any case, it is not at nobody's case that 17A is not required.
17A is required. Yes.
Now the question is that in every public servant case,
To the competent authority.
no, governor oblique competent authority, obviously, governor.
Yes.
Point is, where does the role of the police officer then remain?
After the registration of the crime.
So that's the
That's
debate.
where we'll have to
debate.
answer.
That's the debate.
Yes.
That's the debate. Then 27.1. In this case, directly approached, 27.2. The governor not concurred, took a different view and passed a cryptic order. Then come to page 40. This I have covered now.
Yes.
Police officer is fully covered
Yes.
in the debate which your
No,
lordship
this
just-
argument is over now. Yes.
And then your lordship's judgment is also cited.
Yes.
Now para 29 is really a para about this act. It's a point I'm keeping alive. I'm not
Yes.
It's a point I've fully said there. Not by any remote stretch shown to be part of the discharge of my official duties. That's the
That is, now we have come to the crux.
So therefore, Section 17 grants protection from decisions taken or recommendations made in the discharge of their official duties. All relevant timelines and record. Now, this is not by itself the crux. It is the crux because in this case, you have shown me nothing as to how I have been involved in the discharge. Where this is. That is why it's a crux. That is important to remember.
Yes.
My lord has rightly used the word crux because you have to show that I as a minister, I as a public servant, I as the chairman of a department, I as the file signer, I as the file mover, I as the recommendee, I as the statutory compulsory persona designata, something. Nothing. But your discharge of official duties is because you are a public servant. So the discharge is as big as the universe, the entire universe. Now let's kindly see. Come to 29.2. The official capacity of the petitioner at various junctures enabled him to assist in fabricating record. Now, is this possible? Just kindly see this. This is being told to your lordship's brothers. In pleadings, is this the way to get sanction? And of course, none of this is dealt with. I would have liked the governor to say, I grant sanction of 1 and 2, but I call this bunkum. I reject it. He can still grant against me. See this, brothers. Various junctures assist in fabricating records. Your lordship will not work on adjectives like this. Next, recommendation or decision is made by a public servant not directly or reasonably connected with the official. He is not entitled to protection. Third, it is not the official duty to facilitate the fabrication of fake record. Well, some comma, full stop, some sign. Some collusion, some meeting in a smoke-filled, dark-filled room, doing something, your lordship doesn't. And this is very easy to destabilize. Anybody will take a pot shot. The petitioner cannot seek or obtain shelter under the aforesaid statutory provision as the offences alleged are not in the. This is I'm reading his reply.
Yes.
Consequently, contends the prior approval does not apply at all. Then take your chance. Take your chance. You are the one who went to the governor. You are the one who's got all this thing going. And now you are pleading this also. And you are pleading this on amazing facts of fabrication of records. Not a word, not a single comma, full stop, remotely.
ರಾಜ್ಯಪಾಲರಿಗೆ ದೂರು ನೀಡಿದ ಅವಧಿಯ ಬಗ್ಗೆ ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ ನ್ಯಾಯಾಲಯದ ಗಮನಕ್ಕೆ ತರ್ತಾ ಇದ್ದಾರೆ. ಜುಲೈ 18ನೇ ತಾರೀಕು ಅಬ್ರಹಾಂ ದೂರು ನೀಡಿದ್ರು. 26ನೇ ತಾರೀಕು ರಾಜ್ಯಪಾಲರಿಗೆ ದೂರು ಕೊಟ್ಟಿದ್ದಾರೆ. ತನಿಖೆಗೆ ಸಮಯಾವಕಾಶವೂ ಇಲ್ಲದಂತೆ ಮೇಲಿಂದ ಮೇಲೆ ಟಿಜೆ ಅಬ್ರಹಾಂ ದೂರು ನೀಡಿದ್ದಾರೆ ಅಂತ ನ್ಯಾಯಾಲಯದ ಗಮನಕ್ಕೆ ತಂದಿದ್ದಾರೆ. ಆಗ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳು ದೂರು ಸ್ವೀಕರಿಸದೇ ಇದ್ರೆ ಏನ್ ಮಾಡಬೇಕು ಅಂತ ನ್ಯಾಯಾಧೀಶರು ಕೇಳ್ತಾರೆ. ಖಾಸಗಿ ದೂರುದಾರರಿಗೆ ಯಾವ ಮಾರ್ಗ ಇದೆ ಅಂತ ನ್ಯಾಯಾಧೀಶರು ಪ್ರಶ್ನಿಸ್ತಾರೆ. ಆಗ ಸ್ವಲ್ಪ ಗಲಿಬಿಲಿಯಾದ್ರು ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ. ಟಿಜೆ ಅಬ್ರಹಂ ಯಾವಾಗಿನಿಂದ ಯಾವಾಗ ಎಲ್ಲೆಲ್ಲಿ ದೂರುಗಳನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ವಿವರವಾಗಿ ತಮ್ಮ ವಾದವನ್ನ ಮಂಡಿಸ್ತಾ ಇದ್ರು ಸಿಂಘ್ವಿ. ಅತಿ ಕಡಿಮೆ ಅವಧಿಯಲ್ಲಿ ದೂರು ದಾಖಲಿಸಿ ಅದಾದ ಮೇಲೆ ನೇರವಾಗಿ ಹೋಗಿ ರಾಜ್ಯಪಾಲರಿಗೆ ದೂರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ ಜುಲೈ 18 ಮತ್ತು 26ರ ನಡುವಿನ ಸಮಯದ ಬಗ್ಗೆ ನ್ಯಾಯಾಲಯದ ಗಮನಕ್ಕೆ ತರ್ತಾ ಇದ್ದಾರೆ.
Officer, the clear implication or necessary corollary is that only a police officer has the authority to seek prior approval to lift the bar. This process, much like registering an FIR under 154, 156 or 173, requires the police officer to exercise independent application of mind. This application of mind leading to a further action is the sole and exclusive jurisdiction of the police officer and no one else can replace him. Criminal jurisprudence has deliberately limited the involvement of private parties, ensuring minimal interference of complainant in order to protect the accused's right to a fair prosecution. It is only through recent judgments by the court that the complainants have been given a limited role. This is important, Malas. Complainants have no role except to the extent your lordship permits them in ABCD cases. This limited role is designed to uphold the integrity of the criminal. Why do your lordship not give this, Malas? Because you just can't say that you can kickstart the whole thing in motion. Allowing private individuals, 45, to move the competent authority for prior approval would create an untenable situation where the police officer's authority to apply his mind and determine whether a case merits such approval would be undermined. This is, Malas, the core larger legal question Lordship should, Malas. In this case, these dates I have done, but 29.6 I have done, Malas.
Yes.
18th, 25th and Malas, 18th, 25th and 26th. These are the 3 dates in 29.6. Then, Malas, the SOP.
When was the approvals, before the private complaint, when was the private complaint registered?
13.8 is the private complaint.
Private
registered.
complaint.
13th of August.
Right. 18.7. No, 18.7 is the first complaint.
The first complaint. 25.7 is the supplement.
18.7 first complaint.
25.7 supplementary information.
Yes.
26.7 approaches the governor directly. Can you note one moment? Same day he issues show cause. 26.7.
Fine, that is argued. Yes.
And then Malas goes on.
That is
13.8. 13.8 is the
That is because Lalit Kumari says when a cognizable offence is brought before the court, brought before the police, crime should be registered with, everything should be over in 1 week and crime should be registered. If it is not registered in 1 week, next rung. There, if it is not registered in 1 week, next rung, that is 200 before the magistrate.
Well, then what?
That's what, no, that is the purport of Lalit Kumari.
My lord is absolutely right. What happened to Lalit Kumari when Sashikala Jolie was pending for 24 years? 24 months?
That is approval, not Lalit Kumari.
No, but Malas, I mean, it's the same.
No, that parity we'll see what has happened later.
No.
Because that is something that has happened now during the pendency of this petition.
Yes. No, that is the judgment has come. I mean, the order has come.
Order has come now. It was pending 21. Yes.
Then, Malas,
I am surprised that is approval or sanction is not.
The lordship said so. We checked up. We were also surprised.
Yes, it is approval. Yes.
Now, Malas, last, I'm just ending, Malas. I want to just cover some facts and then I'll try and end. Lordship, give me a few extra minutes, Malas. I want to.
No, take your time.
Malas, 218 is page 46. I say it is virtually.
218 stage, I think, has
virtually
not yet
conceded. No, just read this one para only. It is virtually conceded. The Honorable Governor has, apart from granting prior approval, also proceeded to grant sanction. Your Lordship is right, but that's not what the Governor thinks. The Governor says, I am granting sanction. It's written there, Your Lordship has seen that. During the course of the submission.
218 is what is 197 under the CRPC.
Correct, 197. During the course of submissions, the learned senior counsel of R2 made a categorical statement that the impugned order is not a sanction order of 218 and must be read only as an order of prior approval. Your Lordship will record this because
you need not labor on that.
Provided it is recorded. What happens is ambush points are taken. Either side appeals and we say, no, this is not decided by the judge. But why will the judge decide this? You have conceded it.
No, that is in the written submission also.
Yes, also. Yes. Therefore, Your Lordship, just take that note. I am not arguing for that reason only.
Yes.
Otherwise, I am demonstrating completely that this is wrong. But anyway, he's saying that it is to be treated This itself is non-application of mine, my lord. To start treating 218s or 197s as 17A is itself non-application of
No,
mine.
no,
But
it's,
leave that aside.
they operate in a
Leave that
different
aside.
thing.
Now, my lord,
Because 197 is after investigation.
yes, yes. Now, my lord, no, he's saying treat it now as a 17A order, prior approval order. That's
Yes,
all.
yes.
Now, my lord, page 47 is very important. Well, it's 3 or 2 very serious errors of law were made, and then the facts. Natural justice was brushed aside on the simple point. Notice was given to me, and so what? I didn't send you the other 2 complaints. I'm not required to give notice at all. That's the very, very far-reaching. So, first argument, I gave you notice, but I'm not required to give you notice. But since I'm not required to give you notice, I'm not required to send you the other 2 complaints. So my own definition of natural justice applies. And third, so what does it matter, Mr. Singhvi? There is no prejudice to you.
ಸಿಎಂ ಪರ ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ ವಾದ ಮಂಡನೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದರಲ್ಲಿ ಪ್ರಮುಖವಾಗಿ ಟಿಜೆ ಅಬ್ರಹಾಂ ದೂರು ದಾಖಲಿಸಿರುವ ಸಮಯದ ಬಗ್ಗೆ ತಿಳಿಸ್ತಾ ಇದ್ದಾರೆ. ಯಾವಾಗ ಇವರು ದೂರು ದಾಖಲಿಸಿದ್ರು, ರಾಜ್ಯಪಾಲರಿಗೆ ಇವರು ಯಾವಾಗ ದೂರು ಕೊಟ್ಟರು, 7-8 ದಿನಗಳಲ್ಲಿ ದೂರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ ವಾದ ಮಂಡನೆ ಮಾಡಿದ್ದಾರೆ. ಅಧಿಕಾರಿಗಳು, ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳು ದೂರು ಸ್ವೀಕರಿಸಲಿಲ್ಲ ಅಂದ್ರೆ ಏನು ಮಾಡಬೇಕು ಅಂತ ನ್ಯಾಯಮೂರ್ತಿಗಳು ಮತ್ತೆ ಪ್ರಶ್ನೆ ಮಾಡ್ತಾರೆ.
Officers.
Yes, for the others. But in the present case, Kannada seems to be the chosen language. This is in the other cases. Here, on the same day, on 26th July, he proceeds.
Yes.
In the present case, English translations were done by the governor's office is not borne out from the records. Whereas in the other cases, investigating agencies are directed to file translations. There's an order noting. Now, this is the direct proof. Well, this matter, this particular order must be set aside. Whatever order he has to pass, etc., is a different matter. The Honorable Governor, on the basis of petition accompanied by more than 100 pages in Kannada, come to the conclusion the allegation of serious nature and prima facie need action. Also notices the complaint is filed to the Lokayukt police. It is rather surprising and ironical that the Honorable Governor, unable to read and decipher Kannada, is also able to digest documents of hundreds of pages, etc., etc., and issues notice immediately. There is undue and inexplicable haste. This is not a facetious thing. It all adds up in the overall. It's not just a light game that I'm saying he doesn't know Kannada. That's not the point. He's not expected to know Kannada. I'm not suggesting a lordship. In fact, in the old days, there used to be a bar that you're not, even today is a bar. You can't be from the same state if you're a governor. The application for prior approval.
It's all right. How can you interfere? Yes, I am aware of that.
The application for prior approval sanction is received by the Honorable Governor. Addendum is on 26th. Addendum is also received same day. Let us kindly see page 51. Opportunity of detailed hearing of 3 hours is provided. And by 10:30 on the same day in the night, 10:30 p.m., a show causes notice issued. A process in such a manner by one of the highest constitutional authority against another highest constitutional functionary is unheard of. I'm saying this with a sense of responsibility. Such application, the Raj Bhavan would on the same day reach the governor, and then hearing to a private party takes place on the same day, a show cause. This is all Article 14, etc., etc. And your lordship will see the totality of the earlier arguments also. Then, Malats, 31.3.4.1 is page 52. Sashikala Jole, all the dates are given to your lordships at one place, at page 52. Murugesh Nirani is the other case.
That is also pending.
Returned on 28/8. All is happening after this case has started. He's either returning or rejecting. Approval is only my case. Now you have to explain the delay. Well, it happens even in the judiciary. Sometimes after 2 years, the matter is put again for clarification. So here, after 2 years, in Nirani's case, he sends it for clarification on 28th of August. Then, same thing about H.D. Kumaraswamy, returned to the requesting authority. Then, it is very clear the dates are all after the hearing of this matter has started or after this matter has become a dispute. Not hearing started, but dispute. Then Wallace, application of 13th of May submitted for sanction was returned by the governor in June 2024. On 21/8, investigation replied. On 28/8, the application was returned for English translation. Well, by the way, each of these, that is Wallace, page 52, all the cases except Shashikala, page 53, all the cases are returned after they come back from the clarification, further returned for translation. Well, I hope I'm clear. Take, for example, 53. My case, the same day, the night, same thing. Now, let us see this ground. This is very, very important, 53. In Shashikala, he does exactly what I've been laboring the whole day today. He did not do in my case. That is quoted. It is quoted once. He has given, I'm not saying it's right. I'm not saying who will challenge, not challenge, what your lordship will decide. But is it anything your lordship found? Just glance at it. But any word similar in my case? Please. In the chief secretary in his report says on 23rd of March, no proposal for grant of any tender. In such circumstance, the question of asking for a bribe does not arise. This is what I wanted, Malas. This is the meaning. Your lordship is asking me what the review judicial. This is judicial review. We don't need.
Wait, sir. I'll get back to you. Wait. Yes.
In order to attract the provision of 730, there must be a receipt for the bribe amount. The mere statement one was paid 25 lakhs, paid whether he received the amount is not clearly disclosed. For sanction on inquiry necessary to prove the demand of illegal gratification. So while he's doing the ingredients of POCA, he's writing, and then while he says, hence I find now.
20.
Then while para 20 is read, it's already read. Then while 55, I will skip till 59 because I want to take a lordship's 10 minutes on that dates. 55 to 59 are largely dates, fellows. Your lordship may just give me, and then I'll come back to it because the matter ends at 62, but just come to 63. Just come to 63.
List
Now,
of dates.
Yeah, they just note on the side.
Yes.
All these documents are in the writ or filed by them. Number two, I have not gone into it. My learned friends have gone into it meticulously in the arguments. Half the argument, 3/4 of the argument, Mr. Maninder Singh was on these facts. 3/4 and others. But I want to now show the true facts. And what I've done in the table is document 1, document 2 I put on the left side. What she's got? 63.
Yes, yes.
I made one compilation of all. They're already there in the writ or elsewhere. There are 4 new documents. One is Shashikala Jole, which is not a new document, subsequent development. One is the plan, which is all are mentioned. Apart from Jole, each and every one is mentioned both in my petition and in the cabinet sanction or denial of sanction.
All right.
All mentioned. Now just see the startling consequences very quickly. Malas, 92, your lordship has a notification. Then Malas, the old fellow, the earlier owner is Malas Devaraju in item 4. When I say 4, I mean document 4. Malas.
So, Devaraj is the owner.
Then owner.
Was not there a relinquishment in favor of one Cheluraya or something? Mailaraya. How did Devaraj become the owner?
No. That is much
1945.
subsequent to that a release deed in favor of Devaraju.
Where is the release deed in favor of
Yes,
Devaraj?
give me the page. Is it on record? It is mentioned. Where is the and the averment in the writ? And the averment in the writ.
Now, since you are replying on facts.
No, it's very
that
important.
Should be clear.
Very important. Very important.
It's 10th of April 1993.
Yes, Rangnath.
10/4/93.
ನೀವು ಹಾಕಿರೋದ್ರಲ್ಲಿ there is one relinquishment deed in favor of one Mailaraya or something. Yes.
Now,
1935. It was 1935.
No, let us see. The date of the writ. There one thing.
Hilary was 1935 from the same family.
What the date?
10/4/93.
10/4/93 is Wallace in the documents file. Give the file to my lord. Page 11.
We gave it in the morning.
Page 11.
Oh, it is release the land in favor of Devaraj, is it?
Yes.
Yes. We are talking of 93.
Huh. Which is that I have not seen this document at all.
It is.
Where is it in the original document?
Yes,
Right.
Rangnath, you have not produced this? No, which is this 10/4/93 document?
No, this is produced now, Wallace. It's produced.
Now it's not a part of the record. No, nim record allu hakilva adu.
It is recorded in the writ. It is recorded in the cabinet thing, but document is this. Cabinet.
Where is that document?
This one, page
It
11.
is given in the morning.
That bunch we given once.
In the morning.
All of it is in the writ or the cabinet decision. This bunch. Kindly give the bunch. No?
All right.
No, morning. Just show the bunch.
ಬೆಳಿಗ್ಗೆ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹಾ.
This document mentions in the writ.
It is not in the.
It is mentioned in both Malus, my reply to the governor and in the cabinet decision.
Yes.
Now Malus, kindly come to, I obviously can't read it.
No, no, that,
ಇದು ಏಷ್ಯಾನೆಟ್ ನ್ಯೂಸ್ ನೆಟ್ವರ್ಕ್ ಪ್ರಸ್ತುತಿ.
ನೀವು ನೋಡ್ತಿದ್ದೀರಾ ಏಷ್ಯಾನೆಟ್ ಸುವರ್ಣ ನ್ಯೂಸ್.